Hi, class. I'm going to go ahead and talk to you a little bit about corporate intellectual property. There are different types of intellectual property, and interestingly enough, it can often represent a lot of wealth within a corporate framework. So think about things like drug formulas, music, movies, product design, secret recipes, and so forth, patents and so forth. What is intellectual property? Interestingly, intellectual property was mentioned in the Constitution. Congress shall have the power to promote the progress of science and useful arts by securing for limited times to investors the exclusive right to their discoveries. It's interesting, if you were ever inclined to review the historical background for recognizing intellectual property, it is oftentimes for the fledgling or the growing nation to be sort of always attempting to acquire, however, by any means necessary, the intellectual property of countries that are more developed. So, you know, back, and the same probably goes for industries, right? You may have a fledgling member to an industry trying to catch up with the bigger dogs, and you know, and the tendency there is for the smaller company to sort of push the boundary as far as getting access to different types of intellectual property, or sort of blurring those lines. And I don't think you can say, you know, the United States has never engaged on this as sort of the bad guy, where, you know, they were more inclined to be less protective of intellectual property. If you look back, the one that's coming to mind, Charles Dickens would complain about the US book market, right? Because they were always ripping off his stories written in England. More modernly, you can find on the internet recordings of Steve Jobs saying that, you know, the Apple relentlessly stole ideas from other companies, right? And then, you know, more recent than that is Steve Jobs saying that he would go thermonuclear war on anybody that would steal the intellectual property of Apple. So a lot of times it depends on where you are as far as dominating the market, or your company's size, or your country's size even. You know, a lot of our negotiations with China these days involves, hey, how are you guys going to protect our intellectual property? Movie industry, for instance. So what is intellectual property? Intellectual property is any property resulting from intellectual creative processes. That means things that come from your mind, right? The framers of the Constitution recognized this need to protect and promote intellectual property more than 100 years ago. Laws protecting patents, trademarks, service marks, and copyrights are explicitly designed to protect, nurture, and reward inventive and artistic creativity. All intellectual property owners may license to another party to use their trademark, copyright, patent for certain purposes, right? So a licensor must maintain some form of control over the nature and quality of goods or services sold or rendered under the license. So you can own intellectual property, but you can also license the right to use it from the owner. So the first type I want to talk to you about is patents. A patent is a grant from the government giving an inventor the exclusive right or privilege to make, use, or sell the invention for a set period of time. A patent may protect a product, it may protect a process, or it may protect a design. In order to obtain a patent, an investor must convince the U.S. Patent and Trademark Office that the product, process, or design is genuine, novel, useful, and not obvious in light of current technology. Unlike many other countries, the U.S. awards patent protection to the first person to invent a product, process, or design, not the first person to file a patent application for said product, process, or design. The patent owner will frequently grant exclusive or non-exclusive licenses to others to enable them to make use or sell the patented product, process, or design, in return for which the patent owner would typically be paid a royalty on the sales of goods manufactured or sold under the license. Patent infringement is the making, using, or selling of another person's patented product, process, or design without permission. Copyright. A copyright is the author's exclusive right to publish, print, or sell a product of her intellect for a certain period of time. So copyright is another form of intellectual property. To obtain protection under the Copyright Act, a work must be original and constitute. It's got to either be literary, musical, or dramatic work, pantomime or choreographed work, pictorial, graphic, or sculptural work, film or another audiovisual sound recording, or architectural work. So those are the 5 things that we are able to copyright. Well, it's not possible to copyright an idea. The particular expression of an idea is copyrightable. Compilations of facts are copyrightable, provided they are compiled facts and are selected, coordinated, and arranged in an original manner. Copyrights can be registered with the U.S. Copyright Office. They don't have to be, though. A copyright grants its holder the same monopolistic control over her creation as a patent or trademark. However, a copyright may be obtained only for works of art, literature, music, and other forms of authorship, including computer software. Copyright infringement is the using of copyrighted form or expression of an idea, even with slight variations without permission. Unlike patents or trademarks, federal copyright law provides a statutory defense to a claim of copyright infringement. The defense is called the fair use doctrine. Section 107 of the Copyright Act permits a person or organization to reproduce copyrighted material without paying royalties as long as the reproduction constitutes fair use. So that includes, but it's not limited to, reproduction for purposes of criticism, commentary, news reporting, teaching, ding, 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 scholarship, or research. And then finally, once a copyright owner sells or gives away a particular copy of a work, the copyright owner no longer has the right to control this distribution of that copy. And before I finish with this section, well, let me go ahead and say it then. A trademark is a distinctive mark, motto, device, or emblem that a manufacturer stamps, prints, or otherwise affixes to the goods it produces, so they may be identified on the market and their origins made known, right? Salamanca coffee, clearly a rip-off of Starbucks coffee. The owner may establish a trademark either by registering the mark with one or more states or with the U.S. Patent and Trademark Office pursuant to what's called the Lanham Act, or prior use sufficient to warrant protection under the common law. Once a trademark is established, its owner is entitled to exclusive use of the trademark, using a mark sufficiently similar to a protected trademark so that the mark actually reduces the value of the protected trademark, or 2, lessens the protected trademark's capacity to identify the protected trademark holder's goods or services, is called trademark dissolution. So those 2 things are trademark dissolution. Anybody Want to meet me for coffee at Salamanca? So in 2002, the American lingerie retailer Victoria's Secret bought a case against Victor Mosley, proprietor of Victor's Secret. Sounds a little sus. A small sex shop in Kentucky, proceeding with the case even after he changed the name to Victor's Little Secret. The basis of the action was one of trademark dilution. Victoria's Secret claimed that the negative association with the sex shop tarnished their brand and reduced its recognizable uniqueness. Sort of ironic, I suppose, if you go into a Victoria's Secret. I'm actually surprised Victoria's Secret doesn't sort of have its own line of things that Victor may be selling in Victor's Little Secret. But anyway, initially the court ruled against Victoria's Secret on the grounds that the trademark dilution suits actual harm to the brand needed to be demonstrated. However, as a result of this case, the law was changed in 2006 so that only the likelihood of harm needed to be shown, and the original decision of the court was overturned. So you can sort of see what I mean. Congress kind of jumped in there to protect Victoria's Little Secret, or Victoria's Secret from Victor's Little Secret. Sort of big guy, little guy, no pun intended, analysis there. But you know, there was a period where Victoria's Secret was small enough that, you know, it would have been interesting to see. Well, I guess this is an old one. Do they still have, was it Fredericks of Hollywood or something like that? You know, hey, they're infringing upon our intellectual property. And, you know, like I said, when you're the little guy, you tend to want to grab at what you can in the market and pull it in, versus when you're the big guy, you're looking to push outward, right? And keep other people from, you know, this territory that you think you've established. So when you do think about intellectual property and corporations and so forth, you know, think about it in the context of competition, right? As it's definitely a space where people are competing to protect or to grab at intellectual property. And think as well about how much maybe easier, maybe more difficult, or maybe just impacted the protection of intellectual property can be in an environment where it is so easy to steal. And, you know, because of the internet, right, you can have, you know, you can have real, you know, you can find something that you've built all the way across, you know, the world. And, you know, so the idea of protecting yourself and your ideas, you know, is worth thinking on. In fact, so much so, if you get a chance, I do this in my business law class, but Google Everything is a Remix. And it's a really good series of YouTube videos on how there really are so very few new ideas. A lot of times it really is a competitive race to the market, winner take all idea in an environment where that's not really how things work. You know, we tend to stand on other people's work and you know, so anyway, Google it and watch it. It's well worth the time if you didn't have me for Business 105. And the last one I want to talk about are trade secrets. I think trade secrets are, you know, pretty tied to business and business organizations, right? Because it's information or a process that gives a person or a business an advantage over competitors who do not have access to the information or process. Trade secrets include things like customer lists, pricing information, marketing techniques, plans, research and development, production methods, and generally anything else that sets an individual business apart from and would have value to its competitors. So here we're looking at KFC, right, who's got the secret recipe. I don't know, do they still advertise themselves that way so much? When I was a kid, that was a big deal, right? The Colonel's secret recipe, and people's moms would try to replicate it and whatnot. Trade secret protection extends both to ideas and to their expression. So hopefully you found that interesting. Like I said, Google Everything is a Remix and give that series a watch. It's worth your time because it'll give you another viewpoint on how to analyze intellectual property and how we protect it.